Hi everyone, apologies for the slight delay there. Welcome to today's Fieldfisher webinar. And today we've got a really interesting topic. We're going to be digging into the recent developments and emerging trends that the digital advertising space has been subject to over the past few months. And safe to say, Europe keeps giving us some interesting content, guidance, decisions to talk about. So there's lots to share with you in today's session. So just a quick intro, I am Felicity Fisher. I'm a partner based out here in the Fieldfisher Silicon Valley office. And today I'm joined by my two fantastic colleagues, Richard Lawn and Paul Lanois. And together we're going to take you through some of the practical insights into how some of these recent developments and trends are impacting the space. So without further ado, I'll hand over to Paul, who's going to kickstart with some background.
Hi everyone. So let's begin then. So as you can see on the slide here, there have been quite a lot of recent developments in the AdTech space. There was, of course, the decision from the Belgian court in relation to the IAB's TCF framework, which my colleague Flick will talk about later on. There has been the Google Analytics decision as well, which I'll talk about later on as well. And even in the past couple of days, there have been lots of news in the AdTech world. There is those media reports as well surrounding an AdTech firm which is facing a huge GDPR fine from the French Data Protection Authority. And earlier this week, there was reports as well about an OYB, which is a privacy activist group, which has kickstarted another wave of complaints against a large number of companies. I think it was about 200 over new companies that they are now targeting in relation to their cookie consent platform. So lots of news in the AdTech space. Moving on to the next slide. On to you, Flick, I think.
Yeah, so, and this is just, to further reinforce the fact that the regulators are kind of calling a bit of time on the ad tech industry. We've had some statements this year from the European Data Protection Supervisor in March, advocating for limits to targeted advertising. So pretty aggressive quote that she sort of published there, saying it's time to make change happen. It's time to set clear limits to online targeted advertising. So kind of reflecting the fact that, this industry has really become the subject of a lot of regulatory scrutiny, in many cases off the back of quite a bit of privacy activism. So Paul mentioned the activist group Know Your Own Business. We all know that organisation because it's Max Schrems' baby, so to speak, the guy that brought down the Privacy Shield and has now kind of taken on a full-time activism role through this group, Know Your Own Business, and he really has had AdTech in his sights. There are also ongoing complaints from groups like Privacy International around real-time bidding that we'll talk about in a second. And we also see comments coming out from people like the UK regulators sort of saying new initiatives must address the risks that AdTech poses and take account of data protection requirements from the outset. So for a long time, I think the AdTech industry has been struggling to comply with lots of the GDPR principles, in part because of the way that the processing chain works. It's very difficult to address things like notice, getting consent, and now we see that there's it's increasingly difficult in light of recent guidance to establish a legal basis based on legitimate interest. I'm going to walk through some of this, but it's really just to reflect on the fact that I think the advertising industry is being asked to take a more proactive step in addressing GDPR compliance. It can no longer kind of sit back and rely on the fact it's behind the scenes in many cases if you're an intermediary, and you are going to have to do a lot more to defend your collection practices and your processing practices, particularly which is the case for many AdTech vendors, CMPs, you're going to be acting as a controller of the personal data that you collect. So next slide, please.
Yeah, so thanks for that, Vic. We're going to be talking about some of the more, legal-focused developments and these complaints that have been coming through around AdTech. But it's really important, in this topic that we don't just talk about the law, that we put it in context. So we're going to talk about some of the industry developments first of all. And obviously, one of the biggest developments recently has been the introduction of the Apple Tracking Transparency Framework, or the ATT, which was introduced in April this year. And this is Apple's push to increase privacy protections and settings for their users on all Apple devices, including iPhones, iPads, and Apple TV. And the framework requires mobile app developers to provide a one-time prompt if they want to track users or obtain access to the device IDFA, or Apple Advertising Identifier. This framework applies for iOS devices of version 14.5 or later, and applies for all new data that's collected, so it doesn't apply to legacy data. And apart from that prompt that I just mentioned, the ATT consent prompt, the framework also gives users a new global settings within their privacy preferences, so that actually, instead of individual apps asking them each time for consent, users can actually turn that off entirely so that they are never prompted to give consent. So naturally, given the big dominance of Apple in the mobile space, and especially in the US, that's had a huge impact on AdTech in the market. Now, according to recent reports, these show potentially there has actually been an increase in opt-in rates for ATT since the framework was introduced. So Adjust, which is an analytics platform, they put out a report recently showing that opt-in rates for ATT are at about 25% overall, but lower in some countries. So Germany has the lowest opt-in rate at 17%, and the UK coming at 20%. And so that gives you an indication of the huge impact that's had on third parties' ability to track and access data through iOS devices. Apart from the privacy issues around this, that's also led to a lot of competition concern too. So the likes of Facebook have been highly critical, but there's also been some regulatory attention as well. And in particular, France and UK's antitrust regulators have put out statements saying that potentially the framework could cause harm to competition. So they're keeping the framework under review. And Poland and Germany's antitrust regulators have actually instigated investigations. And really, it's an interesting case which displays that there's this relationship between privacy and competition, but also a potential clash, because regulators acknowledge that the ATT clearly has privacy benefits for users, but there is a concern that the framework effectively is excluding or preventing third parties from monetizing apps while Apple is able to preserve its own first-party relationship with users. So there's clearly a lot of interesting discussion around the ATT. But what's really important for privacy lawyers to remember is that this is Apple's standard. So in terms of what is tracking, well, that's not based on any legal definition. This is Apple's own standard. And this is really where you are seeking to track users both within your own app, but also using data that's been collected from other companies' apps, websites, or other properties. So cross-service and cross-app data sharing. And it also applies if you're looking to use the Apple IDFA for ad targeting purposes. So it covers a broad range potentially of advertising use cases, but not necessarily all of them. So for instance, the ATT framework isn't implicated if you are collecting data from the app and linking that to third-party data solely on the user's device, and that data isn't actually shared with third parties or sent off of the device. And it also doesn't apply if, for instance, you're sharing user data with third parties for purposes like fraud detection and prevention or for security. So it's Apple's standard and it has its own definition. So that raises the question, well, if it's Apple's own standard, how does that align with, compliance requirements and frameworks? So for instance, we have obviously e-privacy requirements, which are purely concerned with the storage of information on device and the collection of information from the device. And there's also, in the US, CCPA frameworks around the selling of data, so sharing of data with third parties for valuable consideration. And effectively, the ATT sits alongside those. Maybe at some degree of overlap, but if you're a publisher and you've got a mobile app, you're now going to have to think about the ATT consent prompt. But you're also going to need to separately consider e-privacy consent prompt as well. And you can't rely on one to perform the other. And this is a point that Apple's made very clear in its guidance, which is that you might have separate legal obligations, for instance, with respect to e-privacy rules in the EU and the UK, but the ATT prompts is something different. And therefore you might be looking at the possibility of two consent prompts to make sure that you're addressing both. And to some comments on that quickly, it's important to remember that ATT consent, you can't rely on consent you've obtained on a different device or in a different context. And by the same brush, you cannot infer somebody's ATT consent based on their other settings, which effectively means that it needs to be independent and the ATT consent really needs to take precedence and override any other consents provided with respect to that specific device. So what does this mean? Well, for publishers, it means that now they have the task of considering, okay, are we within scope of ATT? And if so, how do we address that? We have some room to think about when we're providing that prompt and the language and explanation we're providing to users within the prompt. And then also, how does that relate to our e-privacy prompt? Maybe it's one we manage ourselves, or maybe it's one we use a CMP for, but how do those two interact and how are they going to be displayed for users? So that's something that a lot of publishers are now thinking through, and I think it's fair to say we have yet to see what's really standard and what's the most common approach adopted. So moving on to the second important industry news or development, and I'm going to hand over to Paul now.
Thanks, Richard. If those developments that you mentioned, Richard, in relation to the mobile space were not enough, there are also developments in the in browsing space as well, because Google has announced that they are pushing back their self-imposed deadline of the end of 2023 for the deprecation of third-party cookies. And this will now begin in the second half of 2024. For those of you who may recall having heard this before, what happened was that Google announced last year actually that they are ending support for third-party cookies in their Chrome browser, and they were planning to do it by early 2022. Once they have figured out how to address the needs of users, publishers, and advertisers, and come up with tools to ease workarounds. But then what happened was that in June 2021, they pushed back the timeline to 2023 in order to give the digital advertising industry more time to iron out plans for more privacy-conscious ads. And earlier this year in January, they abandoned their highest profile alternative to cookies, FLOC, Flock, and they turned to targeting by topics. And now they've announced that they're pushing back this new development, this deprecation of cookies. So why is this important? Why is this news? Some of you may also know that other browsers have already blocked third-party cookies a while ago. You have Firefox and Safari, which have already introduced this feature. Well, it is important because Google Chrome is one of the most popular browsers out there. Over 50% of the global browser market is represented by Chrome, and they Google hosts more than half of the world's internet traffic. So that's that's the reason why this is significant as well. So this means that there is a bit more breathing room for advertisers for the next coming months. But then obviously they should not just sit idle, and they would have to to work around this upcoming cookieless feature going forward. Moving on to the next slide.
Yeah, and actually, just before we get onto the Belgium TCF case, I think it's useful to actually just comment on the fact that as we look towards this, let's call it cookieless future, I think this has also prompted another important industry trend, which is a trend towards the use of first-party IDs. And by first-party IDs, that includes obviously IDs owned and controlled by the publishers themselves. And in that situation, they're very uniquely placed to go and get consent from data subjects to collect that data and to process it, and also to provide notice. But the reference to first-party IDs is also being used to describe a technology that's designed to circumvent the third-party cookie blocking in browsers. So that would include cookies, placed by the publisher's domain rather than by the downstream AdTech intermediaries. So it might work practically, you might, for example, visit a fashion website, you might then go to a sports website, and usually you may then go, for example, to the Fieldfisher website. The point being, you've been to 3 different websites. Now, every time you visit each of those 3 separate websites, you would be assigned a separate unique ID. And for all intents and purposes, you would be seen as a different user at that point, because the tracking that's being done is happening through the publisher's domain. But what's happening is that now publishers and intermediaries are using and finding ways to connect those different user IDs. For example, it might be because each of them shares the IP address. There's various ways of doing it. It can also involve using hashed email addresses. But it's safe to say that the downstream vendors are now using some kind of device fingerprinting or IP matching to probabilistically identify that those 3 separate IDs relate to the same user. So there's some sort of matching going on. And this is kind of increasingly being touted as the technical solution to try and, circumvent or get around that third-party cookie blocking. But it's just a flag that although that's increasingly being seen as the kind of cookieless solution, many of the privacy challenges that come with first-party IDs are exactly the same. So, for example, the fact that information is still being collected from the device or stored on the device, usually through some kind of tag that's put in on the user's browser, for example, that still implicates the e-privacy rule. So we still need consent for collection to facilitate the collection of that information and the fingerprinting that might be done by that third party. And then once we've collected that information, in many cases, it's still going to be considered personal data, and so the GDPR is going to be engaged. And that means that we need to think about things like, establishing a legal basis to process that data and to share it downstream with all of those third-party intermediaries that also want to access the data. And if you look at some of the regulatory guidance, given the way that this involves matching, you've still got multiple third parties who are looking to access this data. The goal here is still to do targeted advertising. I think if you were to look at a regulatory view on this, they probably would expect that consent is a more appropriate legal basis to be relying on to do some of this data collection through first-party IDs. So this all nets out as, it sounds great on paper that it's supporting a more cookieless form of tracking, but actually cookieless is probably a misnomer here, because we've still got a number of the current privacy considerations to factor in to this data collection and processing. And that leads me next on to one of the other huge sort of industry and legal developments that we've seen this year, which is the Belgium Data Protection Authority issued a decision against IAB Europe in relation to the transparency and consent framework. And that decision came down in February this year. And essentially it related to the failure, according to the Belgian regulators, of the TCF to comply with a number of provisions of the GDPR. And the IAB has been ordered to produce an action plan, which they were supposed to have submitted by the 2nd of April, and they did that on the 1st of April. They sent their kind of action plan, which is it's not been published, but it's supposed to outline how they are going to resolve the areas of alleged compliance. And at the same time, the IAB also in March filed an appeal against the Belgium decision. And so this is still very much an ongoing kind of live issue, and it's expected that we'll get a little more, or that the court is going to give us the outcome of the appeal sort of towards September onwards. It's also expected that that action plan is going to, there'll be comments and validation of that or not around September too. So we've got a little bit, it's coming, further sort of guidance and confirmation of whether or not, or the details of that action plan and the outcome of that appeal, I'd say in September. But in the meantime, there are some important sort of points of principle that this case addresses, and one that has caused a bit of a flurry in the AdTech space. So essentially, and just to sort of go back one step to give everyone a bit more background. So what is the TCF? Well, it's basically a framework and a suite of policies that the IAB Europe has kind of put in place to allow both publishers, consent management platforms, so CMPs and vendors to help them sort of comply with the GDPR and the e-privacy directive. So it's a voluntary standard that's out there to assist those companies in the digital advertising ecosystem. And it contains a kind of minimal set of best practices that seek to ensure that when personal data is processed, that users, individuals, are provided with adequate transparency and choice, and that participants in that ecosystem, so all the sort of third-party vendors and intermediaries like SSPs, DSPs, that users are informed about what they're going to be doing with their data. And essentially what happens is that something called the TCF string, which is a set of digital signals created by the consent management platform that the publishers have implemented. That TCF string is used to capture the data subject's choices about the processing of their personal data, and that's then shared with others in the ecosystem to try and communicate downstream whether or not somebody gives their consent to the collection of their data, or whether or not they have exercised any choices around particular processing that is subsequently done by others in the chain. And notably, the IAB, and rather surprisingly for some, has decided that that TCF string is in fact personal data under the GDPR. Now, it doesn't contain a unique identifier for a user, but the reason they came to that conclusion is that it's stored on the user's device as a cookie, so it's retrievable by TCF members who are trying to access it, and it's used as metadata to bid requests made by the user's browser to indicate a user's recorded preferences. It's also kind of associated with that user's IP address. So it was deemed to be personal data. And then separately, the IAB went on to decide that the IAB Europe was in fact also a controller of that personal data. So, that was really based on the fact that they were playing a significant role in deciding how and why that TCF string is processed through the framework and the Open RTB. So, having decided that the IAB Europe is a controller of that personal data, they then went on to assess, whether or not they were complying with their controller obligations. And of course, they had never taken the position that they were a controller or that was personal data, so they were found to be in violation of a number of GDPR principles. And importantly, it was found that they had no lawful basis for processing and had failed to comply with several core GDPR obligations. But probably more significantly was the way that they then went on to kind of look at how the framework kind of worked in practice. And there were some interesting conclusions from the decision which are relevant, I think, to the whole AdTech chain when you look at some of the analysis that was applied. So they basically said that the TCF's policy structurally prevented vendors from explaining their own specific legitimate interests. And instead, because they had to abide by very generic and general text provided by the IAB, it meant that those vendors were actually unable to properly establish their legitimate interests. So pretty significantly, they kind of said legitimate interest doesn't work within the framework of the IAB, given the way that it's currently set up. That is, those AdTech vendors seeking to rely on their legitimate interest, which was an option available to them when they signed up, that doesn't work within the current framework. And relatedly, they kind of said that, in terms of legitimate interests, no one was meeting the necessity requirement for legitimate interests to be applicable, because that would require some amount of compliance with the data minimization principle, which in this case they deemed impossible to establish due to the lack of safeguards surrounding the downstream data use. There's just too many third-party recipients, and it's unlikely that an individual is really going to be able to meaningfully understand how their data is processed by those third parties. As a result, also the balancing test wasn't being met. So you've got a failing of legitimate interest. You've also got a failing of transparency along very similar grounds. So for purposes that are, as people who are familiar with the TCF will be aware, there's 12 kind of set purposes of processing. And when you are a vendor who's signing up to the global vendor list, you identify from those 12 processing purposes, those predefined purposes, which apply to you, and you identify your legal basis, so consent or legitimate interest. And it was felt that those processing purposes were too generic and were not specific enough. And again, they also felt that given the large number of vendors involved, it meant that transparency just couldn't be effectively given. So too many vendors, and even though they were listed, it was, in their view, not really possible for data subjects to be fully aware of them. There's too layered for transparency in that sense. They also felt that it wasn't clearly communicated and in a simple enough way which AdTech vendors will process a subject's data for what specific purposes. So setting a really high bar for transparency there that just couldn't be met within the current framework. And then they also kind of challenged the consents that were being collected, again, not specific enough. Given the generic descriptions of the purposes, so it kind of meant that individuals were deemed to be not sufficiently informed and the consents weren't specific enough. Too many recipients for whom consent was being obtained meant that users would need a disproportionate amount of time to read this information, and so it was felt that any consent given was really just couldn't ever be deemed sufficiently informed. And they also flagged that it was really difficult for users to withdraw their consent, i.e. it was harder for them to withdraw consent than it was to give consent. And one of the requirements for valid consent is that it must be as easy to give it as it is to take it away. So on that basis, they didn't deem the framework itself, so they didn't deem the TCF itself illegal, and they didn't prohibit the TCF, but they basically said that the consents obtained via that TCF are not valid for the reasons we just said, and that reliance on legitimate interests as a legal basis for processing, at least for the profiling and targeted advertising pieces, is not possible under the TCF preferences. So a pretty harsh outcome there for everybody trying to use this to, address the GDPR compliance obligations. And then the final kind of slam big issue really is that they also deemed that the IAB would actually be a joint controller with each of the AdTech vendors, publishers and CMPs. So really kind of following some of the existing case law that's out there. People may be familiar with decisions that came through, the Fashion ID case being one. Really taking that decision and then extending it out to everybody in the chain to kind of say, now you're all jointly responsible for addressing compliance with the GDPR in relation to the processing that takes place through the TCF. So, you know, how on earth people are supposed to practically address that through joint controller arrangements is something that we will wait to see how the industry kind of responds to that. But safe to say that is one of the points that's being very heavily challenged through the appeal process by the IAB. They're also appealing the fact that the TCF consent string should be deemed personal data, or in fact that they should be considered a controller. So we'll wait to see the outcome there. But I think there's already been a trend in the market towards many publishers in particular, and actually in my experience many of the larger German publishers already calling for more agreements that recognise joint controllership more explicitly in the kind of data processing agreements they sign with SSPs, DSPs, and in fact calling for people in the chain to sign up to the same kind of template joint controller agreements, which obviously creates some practical challenges for how, once you're all in the same kind of boat and you're all then jointly responsible for compliance, how that's managed in practice. But that's definitely a trend we're seeing. It used to be the case that everybody had terms that said we're each independent controllers, there's no joint controllership here, and that type of contractual positioning is increasingly getting challenged, and I think off the back of this decision we're going to see that come up more as a conversation piece, and there's going to be more scrutiny over how contracts between the different parties in the chain are being managed to address this perceived joint controllership that exists between all the parties. So we'll wait to see what happens with the appeal process. Next slide, please. So what are we doing? What's happening in the meantime? So obviously we can only speculate, but I think there are going to be some significant, and there already have been some significant kind of effects from the decision. So I think at the moment, many vendors and publishers are sort of taking a wait and see approach for now, at least until the result of the appeal is announced. I think many publishers are obviously dependent on advertising and ad tech to monetize the content they make available to their visitors. And so, at this point, it's not like they're removing targeted advertising from their sites as a general rule, without having other monetization streams in place. And also despite the Belgian regulators making adverse findings against the TCF in this decision, at the moment, there are no other industry standard solutions that provide a consistent transparency and consent experience in the way that the TCF does, leaving this massive question of, if not the TCF, what? It's felt by many in the industry that ad hoc solutions are probably going to create more confusing experiences for data subjects. And given the high bar that's set for getting and delivering proper transparency, getting the right consents, I think it's left many people sort of scratching their head for exactly what they're supposed to do at the moment to address some of these issues. That said, I think there are some publishers and CMPs who are exploring how they might provide additional information disclosures within their cookie banners to address some of the DPA's ruling. And I think, importantly, some ad tech vendors are starting to revisit their reliance on legitimate interest as a legal ground to process data. That, for a long time, has been a ground that people have hung on to, in part because of the practical challenges of trying to get consent if you are a behind-the-scenes vendor with no direct access to the data subjects in the way that publishers have. So for practical reasons, consent was really not an easy option to rely on. It required very, big collaboration with the vendor and essentially a lot of onus on the publisher to get that consent for you. So many had relied on that non-consent based ground. But we're going to talk about this in a second. That's just increasingly becoming a challenging ground to rely on. And then looking to the medium term, I think if the appeal is unsuccessful, the IAB Europe will aim to agree that action plan with the Belgian regulators. That might result in a new version of the TCF, so TCF version 3. And on that front, the IAB appears pretty optimistic in some of its statements that it's made about its ability to create a new version. It's kind of stated in its public sort of statements on this that the TCF can and will continue to improve in ways that better align with the DPA's vision and other DPA guidance. So they've long set out that it's been their ambition for the TCF to one day become a code of conduct, so we'll see where that goes. If they're unable to agree amendments to the TCF that satisfy the regulator, then the industry is going to have to consider other ways, either to provide transparency and get consent regarding AdTech cookie use. Again, that's probably going to result in a rise in ad hoc approaches, or it's going to have to avoid user profiling and move, for example, to contextual advertising. However, we know that there's still a number of issues. Contextual advertising in many cases still relies on the collection of an IP address. You're still going to have those e-privacy issues and need to get consent for that. So it's not a slam dunk solution there. And then what about the long term? Well, I think regulatory and activist concerns about personalized advertising are unlikely to go away. As we've seen from the opening slides, things are heating up massively. AdTech still remains in the headlines on an almost weekly basis, it seems, and regulators are stepping up their efforts and scrutiny of the industry as a whole. So, I think we're going to see more pressure for more compliance, more regard for compliance, regardless of the outcome of this IAB Europe appeal. And we might see more demand for solutions that are deemed less risky. So as I mentioned, contextual advertising solutions, or so-called private marketplace advertising models. And I think the reason why these are probably going to be deemed risky is just that they just involve fewer participants. And that's been some of the thread of issues that have come out from the TCF decision. We saw that the consent failed because there was just too many recipients, and the transparency failed along similar lines. On to the next slide. So as I mentioned or hinted at, there have also been some other interesting legal developments over this year and more generally, all of which have continued to put pressure on legitimate interests as a legal basis for processing personal data for behavioural advertising or RTB purposes. Now, to be clear, the GDPR does not mandate that controllers rely on consent. Legitimate interest is a ground that in theory is available, but it's safe to say that the regulators have increasingly been looking at the AdTech industry and have been pretty vocal about their scepticism over the availability of legitimate interests, particularly in light of the perceived intrusiveness of the underlying processing activities involved and the variety of actors, the lack of transparency and applied safeguards, etc. So this has obviously all bubbled up with the TCF case, which actually cited a number of existing, European Data Protection Board guidance and ICO guidance, all of which has already put big warning lights out there that the regulators really just don't think that legitimate interest really works in many cases. Now, no one's gone so far as to ban legitimate interest, but there's a sort of mounting tide of guidance and opinion out there which reflects the regulator's view that consent is probably going to be the most appropriate ground to be relying on. And we see that in the ICO cookie guidance. I put that quote up there where they kind of indicated that legitimate interest is not considered to be an appropriate basis for the processing of personal data in connection with profiling and targeted advertising. So pretty, as bold as they're going to go in terms of stating their skepticism about that. And there's other similar guidance from other regulators out there sort of conveying a similar sentiment. And then just looking, we talked about the Belgium decision. I think just to sort of add some further context on the legitimate interest debate there. So while the Belgian regulators focused on the applicability of legitimate interests for the purposes of sort of targeted advertising and profiling of users, a lot of the reasoning that was stated in their decision, particularly around the lack of safeguards and significant number of vendors, all appear to relate to all legitimate interests communicated through RTB. So it's sort of suggesting that you know, they're looking for a prohibition of legitimate interests in the current form via the TCF, and they don't appear to be exempting kind of non-marketing related purposes. And I think this is definitely a point that's being challenged by the IAB in the appeal. And then we've also had some pretty recent decisions that have come out from the Italian regulator. So in July this year, they issued an urgent decision against TikTok. TikTok was trying to switch its legal basis from consent to legitimate interests to process user data to run personalized ads. And basically the regulator said you can't do that. They sort of put an urgent decision out to halt that switch. And they cited that they couldn't rely on legitimate interests for a number of reasons. The legitimate interests weren't sufficiently explicit. They referenced earlier kind of regulatory opinion to kind of cite why you know, the regulatory view is consent is a more appropriate basis. In part because of the intrusive nature of the profiling activities. And they just basically, it's very similar sentiment to what we see in the Belgium decision. Everything, you know, the purposes were too generic. They hadn't completed a legitimate interest assessment. And they'd also failed to evidence the adequacy of their age verification measures. And so couldn't exclude the possibility that personalized advertising would be delivered to minors. Again, undermining their legitimate interest argument. And then finally, sort of over the past week or so, there's also been a sort of initial preliminary decision from the French CNIL against Criteo, another AdTech company. And that really relates, as I say, it's a preliminary decision with a proposed fine of $65 million. They haven't published that decision yet. Criteo have got a chance to contend the findings in the fine that's been proposed through a formal hearing. After that formal hearing, the decision, which remains a draft decision, will be submitted to consultation with the other data protection regulators who have to then agree effectively on a final decision. And so we wouldn't expect this to be resolved probably until mid-2023. But importantly, this comes off the back of some complaints that were filed back in 2018 by Privacy International. They filed various complaints involving, other, Oracle, Quantcast, Tapad, Axiom, amongst others. They filed complaints with a number of regulators, and this is the CNIL picking up on that complaint and specifically investigating Criteo. And, we're expecting that the decision is also going to look at the validity of the consents that have been obtained by Criteo and also their reliance on legitimate interests. We've seen from the original complaint that a lot of it was based on similar principles, again, citing failed transparency, failure to properly identify legitimate interests. So we'll wait to see what comes from that decision. But it's safe to say it's yet another blow, potentially, to that legitimate interest ground. So next slide.
Yeah, thanks, Flip. So kind of related to that issue around lawful basis for processing is if you are processing sensitive data for the purposes of advertising and how you establish your lawful basis to do so. And I think the headline here is that this at the moment is very challenging to do lawfully in Europe, but also it's going to become pretty much impossible in the future. And that there are a few reasons for this that I'll just very quickly explain. First of all, we had the decision around Grindr in December last year. That was from the Norwegian DPA. And they've basically found that when Grindr was sharing certain user information with third parties for advertising purposes, Grindr didn't have a lawful basis to do that because it hadn't obtained consent from the users. Now, why would it necessarily need consent? Well, that's because the Norwegian DPA found that the fact that the user was a Grindr user indicated information about that user's sexual orientation, and therefore you have to rely on consent under Article 9 because it's special category data. And that's essentially because Grindr app is focused on the LGBTQ plus community, and therefore they extrapolated and said, well, if you're a user of the platform, the fact that you're on the platform means that we have information about your sexual orientation. Now, that decision wasn't without criticism, and not everybody agreed. So, for instance, the Spanish DPA issued a statement saying, well, actually, we don't think that Grindr was processing special category information. And Grindr has appealed the decision. But there's a twist in that story, because just hot off the press last week, in fact, there was a ruling from the highest court in Europe, the Court of Justice of the European Union, and they concluded that actually information that indirectly reveals specially protected characteristics like sexual orientation, that information should be considered special category data under the GDPR. So effectively what the court did was applied a very wide interpretation, and they said it's not just information that directly speaks to those special characteristics, but it's also information that indirectly reveals them. So in that particular case, a website had published the name of a person's spouse, and that basically reveals their sexual orientation, simply that information. And therefore they said the publication of the information involved special category data. So the fact that the Europe's highest court has taken this wide interpretation is going to have potentially a big impact on what is and what is not special category data under the GDPR, and that potentially implicates all sorts of scenarios, including in advertising, where you may have particular topics or segments based on interests or groups, and whether those now should be considered special category data or not. And just on that note, interestingly, earlier this year, Facebook made an update to its platform, and it no longer allows third parties to advertise based on the certain sensitive topics around health, sexual orientation, and political beliefs. So it no longer allows that. So for instance, if somebody's a member of an LGBT rights group and they've been assigned that topic in Facebook, you can't target the user based on that. So already there's a kind of a shift away from some of potentially this more grey area targeting practices. And then the last point, just to quickly mention, is the Digital Services Act. Now, you might have heard of this. This is a new EU regulation that is not yet in force. It's not yet in effect even, but it has been confirmed and the text has been finalized. And what the DSA is going to do is that for all online intermediary services, it's going to say, well, in fact, if you're doing ad targeting, you're not allowed to do that if you're profiling users based on special category data under the GDPR. So it effectively puts a ban on using that data to target individuals with advertising in Europe. And that regulation, it's going to come into effect either 15 months after it's published, which could be potentially later this summer, or it would come into effect at the beginning of 2024, whichever date is later. So there's a little bit of time for most platforms. It's not there yet, but there is an earlier date for very large platforms. So all of that is to say that the use of sensitive data is challenging now. It will be prohibited in the future, but the real battle line will become, well, what is sensitive data and what is not sensitive data when we're talking about some of those interests, topics, segments, profiling, the rest of it. And I think I'm now handing back over to Paul, who's going to talk through some of the cookie compliance developments.
Thanks, Richard. Yeah, absolutely. There have been a lot of legal developments in this space, and I mentioned earlier that earlier this week, actually on Monday, the NOIB announced that they were sending out a new wave of complaints, more than 200 complaints surrounding the use of a cookie consent management platform as well. And data protection authorities have been very active as well in relation to cookie compliance. If I take the example of France, because France is particularly active in this space as well, in December, so on the 31st of December, so it was really a good way to ringing the new year, I guess. The CNIL issued a fine totaling 150 million euros in relation to Google, because according to the CNIL, users were not able to refuse or accept cookies as easily as they provided the consent. Guidance as well. There have been new cookie guidance issued, well, not really new cookie guidance, but I should rather say an update to the existing cookie guidance. So in May of this year, the CNIL published the updated Q&A in relation to the deployment of cookies. Moving on to the next slide. Google Analytics, and this is particularly a big one, and I know it may at first sight not appear to be directly relevant to the AdTech space, but then actually it is, because so what happened in those decisions is that so you had first in January of this year, you had this Austrian Data Protection Authority, which published its decision concerning the use of Google Analytics by a health website. And the Data Protection Authority held that there was an issue surrounding the transfer of data to Google in the United States, because the data was not afforded an adequate level of protection equivalent to the level of protection offered in the EU. And other European data protection authorities as well followed suit. There was the decision as well from the French Data Protection Authority in February. There was another decision issued as well in recently as well from the Italian Data Protection Authority. So there have been a lot of lots of different developments as well in relation to data transfers. And so the reason why we are bringing this up now is because what was the issue in those cases was that the IP address which of the end user, which was being collected and which was being sent on to Google in the United States, that was what was the concern of the different European data protection authorities. And obviously in the AdTech space, well, the IP address is one of the identifiers which which is typically collected as well, and that's that's the reason why this is particularly relevant in relation to the AdTech industry. Other data protection authorities as well have been very involved as well. So I mentioned Italy. The Dutch Data Protection Authority indicated on their website as well that they are doing an investigation in relation to 2 Dutch websites, and they expect to be able to indicate whether or not this is going, whether Google Analytics will be permitted in the future. And then you had the Norwegian Data Protection Authority as well, which issued a statement, Liechtenstein. So, really what I'm trying to convey here today is that a lot of European data protection authorities have taken issue with the use of Google Analytics, but it shouldn't be seen as only Google Analytics. It's more a wider issue, I think, surrounding the transfer of certain information like the IP address, especially if certain options like the IP address anonymization within the tool have not been enabled. I went very quickly because I realized that we are out of time.
We're running out of time, yeah. And yeah, thanks very much, Paul. I guess to wrap up, just in terms of looking ahead to the future and just some of the key takeaways, I think we might have scared everybody in this call into thinking, oh my goodness, there's so much to grapple with, and it's just getting harder. But when we can't sugarcoat it, there are a number of additional compliance considerations that I think AdTech companies are now really going to have to focus on. I think there's going to have to be a revisiting of the legitimate interest ground, and to make sure and to assess whether or not you can meaningfully rely on that, because I think that's increasingly open to challenge now. So taking a look at what your legal grounds are. If it's consent, how are you getting that consent? If it's legitimate interest, is that something we think really can work in the context of what you're doing? I think in light of what Paul's flagged around data transfer compliance, I've started to see an enormous trend towards much greater scrutiny from some of the bigger publishers of their AdTech vendors' transfer compliance. That is to say, those are publishers trying to do transfer impact assessments, which is something that now has to be done if the data collected involves a transfer of data from Europe or the UK back out to places like the US. And as part of those transfer impact assessments, there's a really big focus on what technical measures vendors can be putting in place to limit the amount of data that's actually ultimately transferred and processed up in the US. So in the context of AdTech, what's being done to anonymize that IP address if possible that's collected? And we're really starting to see publishers come through with some really technical detailed questionnaires and assessments, and if you're trying to win a deal with them or keep them as a publisher, it's now about being able to have a good narrative and a good explanation for how you're kind of helping them complete those transfer assessments, and rethinking through some of the technical measures that you might be able to offer or should be implementing to try and better minimize the amount of personal data that's collected and ultimately transferred. And then I think this issue of joint controllership is going to come up more and more in contracting processes as well. Just thinking about maybe perhaps dusting off your existing terms and thinking about the extent to which you might want to be more clearly and explicitly acknowledging that joint controllership through the data protection terms that you're offering. And then establishing an appropriate allocation of responsibilities between the parties. I think it's going to get increasingly hard to ignore the joint controllership issue, and there's going to be more pressure to have contracts that are more detailed and more explicit in addressing that allocation of responsibility that has to happen when you identify any joint controllership. And then, of course, there's the sort of cookieless future and thinking through how people are going to react to that and better come up with cookieless ways of tracking and thinking through some of the implications of first-party ID use moving forward. So, sorry, a very quick roundup there, but thank you so much for listening to us today. We will be circulating the slides and the recording to all participants. We really appreciate you signing in and joining us today. You can also find this webinar and other webinars that we've done, including a number of really good webinars on the AdTech space by some of our colleagues in our UK office on our YouTube channel. So there's the Fieldfisher Silicon Valley YouTube channel, which is ours for this office, but there's also just the Fieldfisher YouTube channel where you can find other webinars from our colleagues in our other offices. And there's also the Fieldfisher blog. So lots of resources there. And if you have any questions, don't hesitate to reach out to us. So thank you very much for joining us.